All right, please be seated, ladies and gentlemen. We're on the last lap, ladies and gentlemen. Mr. Diaz, proceed.
Just real quickly, I asked the security to go open passport races.
All right, noted.
Thank you, Your Honor. To please the court. A little different topic. I'd like to start off on at the time when this CPS intake referral was made on September 22nd. It came in, and of course, as you've heard over and over from testimony, the allegations regard negligent treatment, maltreatment, and it was an intake showed that there was no domestic violence. Now, why is that of any importance? Well, the department has been accused of not following its policies and procedures. Mr. Buck, in his closing, showed you excerpts from Exhibit 70, the Domestic Violence Practice Guide, that the social workers hadn't been trained on the practice guide. If you remember Forrest Jacobson testifying that when that was originally, the term they used is rollout. When the policy was rolled out in July of 2009, all DSHS workers received the policy, the information. But as I showed you earlier, this slide of years of experience in these areas, people, domestic violence wasn't anything new. The guide was something that was adopted and new, but what's the importance of the guide? But to point you to the policy, to give you direction to where is the policy. And so I've asked many witnesses, including Dr. Rycraft, but also our social workers, where is the policy? You go to Exhibit 70 on page 15, it outlines the 3 locations in the practice and procedure guide where the policy can be found. We covered it. And you'll have Exhibit 293A, which was what was in effect in 2010 until November of 2011, that policy. And that was testimony from Ms. Rogers regarding when the policy changed and there was an update. And there was some confusion because we went from a lettering system as to the paragraphs with numerical sections to now strictly numbers. But the policy did not change. There was the intake policy, which was part of that section 2220, which talked about an intake and how to fill out the form at intake. And you'll clearly see in the referral it says no, because there was no known history at intake that there was domestic violence going on in Sdn Powell's residence. And then in 2331 of that practice and procedure guide for 2010, you'll find then the other policies that are referenced in Exhibit 70, that DV practice guide, which were again were followed. If there's no domestic violence and there's out-of-home placement, you don't do a further assessment. Rocky Stevenson followed that policy. There was no further assessment at that time. It also goes and has it again that you interview the perpetrator. That was done. The person that was who believed responsible for the neglect, maltreatment wasn't Sdn Powell, it was Josh Powell. And Rocky Stevenson interviewed him. Also, it calls for face-to-face interviews with the children. That was done. Not only was it done, they also had additional forensic interviews that were done at the ACA. And actually, Detective Sergeant Bird also participated and observed those forensic interviews. Policy was followed. This was not a domestic violence case. That was a theme that you've heard throughout the testimony from the witnesses that we've called. This was not a domestic violence matter. This was a neglect, maltreatment matter And to be cautionary, the department advised the judge, who already knew from the non-parental custody action, that there was a disappearance. That was nothing that was ever concealed from the judge or the court. And in fact, every document you see from what's referred to as the ISSP's individual service and safety plans that were filed by Ms. Jacobson, the first thing you'll see when you look at those exhibits, and just so you know where to go find those, Exhibit 33 are the ISSPs that were prepared by Ms. Jacobson in October. And then you go to exhibit number, and there are two exhibits, 245 and 246, were the ISSPs that Ms. Jacobson submitted to the court in January of 2012. But the first thing you'll see in each one of those is a restatement of all of the allegations. There's no way that the judge is going to misplace what was originally alleged, because it's repeated over and over again in these documents. But on the 17th of October, Rocky Stevenson prepared what was referred to as the Sdn Risk Assessment. And as he finished the completion of that, because of the facts that were known, it came out with a low score. So he overrode the score to give it a higher risk value. The higher the risk value, the more services within the guides that the department follow are available in that action, whether it's for the parent or if it's going to be for the child or children. And so he overrode the low risk to make it a moderately high risk. It's not the highest risk, which is high, moderately high. Now, going into the month of November, you'll see that with all of the blue shields on this calendar are contacts with either the West Valley Police Department or the Pierce County Sheriff's Office, primarily with Detective Sergeant Sanders. Each one of these entries, you're going to find emails. You're going to find the communications with these various folks. You'll see that there were still supervised visitations occurring. And in fact, on September 6th was the first supervised visitation with Miss Griffin Hall at Mr. Powell's new residence out in Graham. Prior to Miss Griffin Hall going out for that visitation in Graham, several days earlier on the 3rd of November, Dr. Manley and Forrest Jacobson had taken the boys. Forrest took the boys out to Mr. Powell's new residence for the first time. And there, Forrest did a walkthrough of the residence. Dr. Manley observed his second session, now observing Mr. Powell interacting with his sons. And that information is all contained in Dr. Manley's psychological evaluation. Again, a report that you haven't had the opportunity to sit down and read. It's exhibit number 18. I'm going to ask you to read that. It's 22 pages. Look at the details that are there. That information was all before the court at the hearing on February 1st. In there, you'll see information about Ms. LeMay. You'll see information about Josh and his comments and commentaries at the counseling session with Ms. Murigi. You'll see information about what was obtained from the divorce files, about all of these activities when Josh Powell was a teenager. None of that was hidden from anyone. It was there. It was there, and the court actually said that they reviewed it, which we would assume the court would do. But that was just one of many different reports that were filed for that hearing on February 1st, containing a wealth of information. So here in November, we have a number of activities, visitations, contacts with the police. That's when the department, initially with Rocky Stevenson and with the Assistant Attorney General Long, pressing West Valley, Utah for any information to assist us. You heard that from the Assistant Attorney General Long that Utah wasn't going to release anything unless there was a threat of the boys going home. So Mr. Long had to actually talk to Mr. Bassett and to encourage him to file a motion to convert the dependency to an in-home dependency in order to spur a source of information to come up with anything. But you'll recall that early on in early November, that all the department was being told that there was 5 or 6 images. Those are in emails. Please read those. But Ms. Jacobson, throughout the course of her work on the file, was receiving reports from Ms. Narigi, the now therapist for the boys, in order to help address any of their emotional or psychological issues that they had. We still had throughout the month of November, Ms. Strickland once a week going into the Cox residence to also provide the counseling therapy type services. And you heard last week from Ms. Strickland how things improved over time. But you also heard from Ms. Strickland that Charlie and Braden, and really specifically Charlie, continued to press, I want to go home to my father. She said that it was evident that those boys loved their father. During this time, we also had disclosures that were being made, whether they were at visitations or elsewhere. For example, I don't know if let it flip. Here we go. Here's an email which was Forrest Jacobson sending it to Gary Sanders. November 29th of 2011. She said, I wanted to inform you so that you can pass it along to authorities in Utah if you think it is appropriate that at the visit with their father this past Sunday, Braden told his dad out of the blue and not correlating to any conversation they were having, they found mommy's body in the desert. I have spoken to the visit supervisor who I've asked her to detail out the visit subsequent to that remark, as she stated it had an obvious effect on Josh. I also spoke with Mr. Cox tonight, stated that Charlie was talking on the phone to a friend of his peer from Utah when he stated, when asked if he would be coming back to Utah, that he would only be back in Utah if mommy came back, but that mommy might be dead. That information was sent to the Pierce County Sheriff's Department, to the liaison with the West Valley City, Utah. And you have Gary Sanders then advising Ms. Jacobson that he passed on the email to Detective Maxwell. The department's concerned. They were concerned throughout this entire matter. They're trying to do what's best for both those boys, at the same time recognizing that Mr. Powell had rights. He had rights to visitation of the boys, and for the best environment that available for the boys, that's where those visitations were now occurring. Moving along to December. Again, monthly, we had health and safety visits by Ms. Jacobson. She actually was out there on the 1st of December to the Cox residence, where she again met with the boys. Also discussed how things were going with the Coxes. We had on the same date, we had contact between Mr. Maxwell or Detective Maxwell and Assistant Attorney General Long, as we're still asking for release of any facts or information that are going to assist the department. we have concerns. Throughout the life of this, we've had concerns. You'll see emails in exhibit number 270A and in 270B, which again will be going back to you. Communications back and forth with Dr. Manley. We actually had several of those emails we pulled out when Dr. Manley finished his testimony last week to go over those specifically. But that was just several emails out of quite a few number. And I encourage you again to read this information, read these details, see this communication, see what is occurring. But of course, the plaintiffs would have you believe the department did nothing. All we were interested in doing is covering it up. This is all just a cover up. Also in December, we had the session with Ms. Narigi where the appropriate comments in the redirection that she was having difficulty with Josh Powell occurred. Well, not only is that noted in the case notes, which are part of Exhibit 55, it was also communicated to Dr. Manley, and Dr. Manley includes it in his report, the same report that went to Judge Nelson for her review and consideration at the hearing on February 1st. That information also was included in the guardian ad litem report that Julio Solano prepared. I'll encourage you to see his report. That actually is a part of Mr. Bassett's emails that are part of Exhibit 278. You've got all the communication we had back and forth with Mr. Bassett. Those are all exhibits that were omitted when Ms. Jacobson testified back in early March. And included in there is Mr. Solano's report. I want you to read his report, the report that was given to the court. In there, it talks about these comments that the boys are making. Comments also including that you want to do something about my father, and I'm paraphrasing, because he'll kill you. Information that Judge Nelson was fully aware of. Look at her order that was entered on February the 1st. Her order is exhibit number 257. There's actually two separate exhibits. One that was for Braden's action, one for Charlie, because they have separate numbers or separate orders, but they contain the same information. And you'll see within that order that it indicates that she received the guardian ad litem report. She checks it, she initials it. That was just one of many reports that she was provided. She also indicated that she had received the ISSP from Ms. Jacobson. Read that ISSP, because the plaintiffs would have you believe that there's just a sentence that was in the ISSP, but there's a culmination of various reports that are all being provided to the court. And we know that on February 1st, when Judge Nelson ordered that Mr. Powell submit to a sexual evaluation with a polygraph, that she was fully aware of vast amounts of information regarding Joshua Powell, the disappearance of Susan Powell, the Stephen Powell situation, the charges against Stephen Powell, the house of horrors that were described by some of the detectives who failed to put the boys in protective custody when they found this so-called house of horrors. A lot of information contained in those records, and I encourage you to read them. So here we are in December. We now have Pastor Atkins who's come forward and has been offered up as an additional supervisor to supervised visitations. you have all of his reports are in these exhibits. You can see exactly what he wrote, what he provided to Ms. Jacobson. And you heard him testify. You heard him testify that he was receiving, as a pastor from his congregation, pressure to separate himself from Mr. Powell. But you heard him testify that those boys loved their father and that he believed everything he observed, that the feeling was mutual between father and sons. He also testified that probably out of anyone in the locale, since Josh and the boys had relocated to Washington State in January of 2010, he probably had the most contact with Mr. Powell and with the boys, because he had testified that he had children that were a similar age who actually went to the same school, eventually where Charlie was going. So read what Pastor Atkins wrote. Before I move into January, another important note was Ms. Griffin Hall, and you'll see emails again that are contained in the exhibits, where she states that as a contractor, they don't work legal holidays. And so Mr. Powell had asked for Christmas and some other holidays to spend with his sons. But Ms. Griffin Hall had to advise that I don't work on holidays, legal holidays. So Pastor Atkins stepped forward and said, on Christmas Eve, I'll take the boys to your house. And in fact, he testified about Christmas Eve, taking the boys to Josh's house. That Josh had Christmas tree and gifts for the boys and had things decorated, pictures of Susan Powell present in the residence, and that they were there for several hours. And then to complete the visitation, they all returned back to the Atkins residence for dinner. Read Pastor Atkins' reports. But moving into January, you'll see in the emails, and you'll see again on this calendar that's on display, all the blue shields. We're still trying to get information from West Valley, Utah, where they had advised, we've got 5 or 6 images, but they also advised the state that they're subject to not only a gag order, but a secrecy order, and that they just can't disclose information without permission. One of the exhibits that you'll have an opportunity to see is a copy of an order that released what ended up being more than 300, perhaps up to 400 images, thumbnail type images of cartoon porn, some of it insensual, that Dr. Manley testified about, which then, from that, led to Dr. Manley doing an addendum report that he submitted on the 31st of January of 2012, where he recommended the psychosexual evaluation of Mr. Powell. He also recommended that there not be consideration at that time at the review hearing, which was actually the following day on February 1st, that the court consider reunification, that it was too soon, that Mr. Powell needed to be evaluated. And in fact, in January, he had actually started counseling sessions that had been recommended and the department supported, that Mr. Powell received separate PhD psychological, clinical counseling. And we just heard this past week from Dr. Whitehill, who was providing those counseling sessions. We also heard from Dr. Whitehill that he last saw Mr. Powell on February the 3rd, 2 days before Mr. Powell killed those boys. And that there was no indicators that from the 60-minute session that he had with Mr. Powell that would lead him to believe that he was either suicidal or homicidal. And as a psychologist, we've heard from doctors that they have a duty to warn if they have any information whatsoever that a patient or someone they're treating could be a threat. So finally on the 17th of January, which was a date that finally received word through Gary Sanders that the secrecy order was lifted to allow some imaging to be sent to 8 people in Washington State who would be permitted only in Detective Sergeant Gary Sanders' office to view, and that those images could not be loaded onto any computer, they could not be printed, and that the order specified the 8 people who would have permission to go to Detective Sanders to view them. Word came out on the 17th of January that those were being released, and later, at the end of that day, they had been. But prior to that, Ms. Jacobson had prepared, in response to a motion to place the children in an in-home dependency, a declaration opposing reunification, advising the court that the department, that they were expecting to receive imaging that had been promised for months from Utah. Her declaration is Exhibit 251A. Please read that. The motion that was filed by Mr. Bassett, which you'll see some of the communications again where Utah is saying, well, we can't release anything. But if there was a threat that the boys might be returned home, then we might be able to give you something. So Mr. Bassett actually filed in early January, it was on the 9th of January, filed a motion to request that Judge Nelson convert the dependency to an in-home dependency and send the boys back to Josh. That's Exhibit 249A. Read that. A lot of detail in there that Mr. Bassett placed in there, all information read by the court. She denied the motion on February 1st, but it's detailed. There's information about the visitations. There's information about Mr. Powell and his comments. There's information which Judge Nelson was aware of. Information that Judge Nelson was aware of when on February 1st, she also ordered that visitations continue as is, knowing full well that the visitations had been occurring in Mr. Powell's residence since November, knowing full well that she had just ordered the psychosexual evaluation, knowing full well that if there was pressure or risk that she could limit visitation, she had the power to do that. The department couldn't stop visitation. The department doesn't have that power, but the court does. The court was fully advised throughout this matter. Plaintiffs criticized, well, it wasn't timely. Judge Nelson was advised about all of the derogatory, disparaging comments that Mr. Powell made over the course of several months. Mr. Serrano was aware of it. It's in his report. You can find his report in exhibit number 55 on page 37. Actually, that's the wrong page. That's Jennifer Graves in the note with Rocky Stevenson. You'll find in exhibit 5270A is where you'll find the report on page 55. And you'll see that Mr. Serrano, you'll see exactly what information he had. You might remember when he testified, he didn't have the best memory. I had to ask him several times to see if he would recall information. And again, he wasn't the best historian. But the report he filed in early January, it's got contemporaneous information that he provided to the judge. And in that report, he recommended to the court, the advocate for the boys, for Charlie and Braden, he indicated to the court that Mr. Powell, that he was in compliance with everything the court had ordered. He also indicated to the court that he was progressing, which is what they look for in a natural progression of a dependency. And in fact, based on that, you'll see in the order that Judge Nelson entered on February the 1st, in her order, she had the same finding. Read her order. It says that Mr. Powell was in compliance and he was progressing, knowing full well about the derogatory, disparaging comments, because it's not hidden. It's in a number of documents that was before the court on February the 1st. Most of those documents were filed in early January of that new year, 2012. I wanted to share with you, just to recall and refresh your memory about Detective Maxwell here just a week ago testifying again, where I asked Mr. Maxwell, do you recall that you had no concerns regarding sexual abuse or child abuse directed at Charles and Braden while in Utah? He goes, I was not aware of any child abuse or sex abuse. And I go, now, Mr. Maxwell, if you had information regarding past child abuse or sex abuse of Charles and Braden in the state of Utah, would you have notified Mr. Stevenson or other representative of either Child Protective Services or the Department of Children and Family Services during the course of a dependency action here in Washington? He goes, yes. Now, there's been a lot made of Mr. Stevenson in that he prematurely closed his investigation. Well, he testified about the normal course of a CPS investigation, and they actually have timelines that they need to comply with. But due to the fact that that was unfounded was the finding and it was closed the end of November, didn't mean that Charlie and Braden were going home. It didn't mean the dependency ceased. What it meant was the CPS investigation was concluded. But in fact, Mr. Stevenson continued to communicate with Utah, trying to assist by getting the images and any other information that West Valley, Utah had. And he continued to communicate with the Pierce County Sheriff's Department for their assistance. He didn't give up. As you heard from Assistant Attorney General Long last week, that's an administrative finding. It has no bearing on the dependency. The dependency continued. And this, the ultimate goal of the dependency is family reunification. And that was still a goal. But that didn't mean those boys were going to go home. Services were going to continue. And based on what the evaluation was of Josh Powell, the court would have dealt with that. So, over the time from the very first contact, March of 2010, until February of 2012, we've noted for you the number of contacts law enforcement had with the department. There were 60 contacts. 60. And many of them, again, are noted in the case notes. They're also noted in emails. And they're all for your review. Now, we had people that had testified during the course of this trial that they had no information about harm or abuse to these boys. We had social worker Forrest Jacobson, Rocky Stevenson, Betsy Rogers. We had Michelle Breland from the Child Abuse Intervention Department at Mary Bridge Children's Hospital, who did the sexual assault, physical assault examinations. Her reports are there for you to review. They're part of the exhibits. You had Dr. Mike Whitehill, who also testified that he had no information or evidence. Paula Strickland, Elizabeth Griffin Hall had no knowledge of any prior harm or abuse. We also had law enforcement, Detective Gary Sanders, Detective Sergeant Teresa Berg, Ellis Maxwell, Steve Downing, the lawyer for the Coxes in the non-parental custody action. He never provided any information to Judge Nelson of any evidence whatsoever of physical harm or abuse that was known for these children. Mr. Cox himself never provided any information. Jennifer Graves, we went over what she said, and that she filed a declaration in support of the Coxes in September of 2011, and never made one mention about harm or abuse. And in fact, read Mr. Cox's declaration to see the information regarding any type of abuse, whether it's domestic or otherwise. If you would call me asking him on cross-examination, would you please point out in these 10 pages any reference to abuse regarding your daughter? There was 2 places. One said emotional and verbal abuse. On the next page, it referenced again emotional abuse. That's it. That information was before Judge Nelson. Also to Julio Serrano, the guardian ad litem, who was assigned by the court as a special advocate for the boys. He didn't work for the department, but he was a decision maker with the department, not only on relocating the visitations to Mr. Powell's residence, but also increasing the visitations. He also was involved in approving Pastor Atkins as a supervisor. There was a number of eyes, not only on Mr. Powell, but on the children that were involved throughout this entire process. None of them suspected that Josh Powell would harm or abuse his sons. So we had Forrest Jacobson. She was asked, actually by one of you, do you believe at any point that Josh would harm the children? This was on March 5th, when she was ending her testimony that day. Her response was, I honestly have a hard time thinking about what happened. It was never on my radar from the information that was available to us that he would physically harm the children. My worst case scenario was that he would try to flirt with the kids. He had been the suspect in his wife's disappearance for 21 months before we stepped in and filed a petition. There was nothing indicated he had physically harmed the kids. No information indicated he would. And they had already been taken once by law enforcement and interviewed. It was not something I thought was going to happen. So again, we have law enforcement taking these boys out, interviewing them, and returning them back to their father. That was known by Assistant Attorney General Long. Who was involved in the dependency action. But then we had Detective Sanders, his testimony on February the 27th. And throughout the life of this case prior to the murder of the boys, you didn't have any evidence that Josh Powell struck his boys or physically abused, committed physical child abuse on his boys. The answer was no, we did not. If that would have happened, I would have arrested him. Then we had Detective Sergeant Berg here on July 14th testify as follows. At any point, did you ever come to knowledge of Josh Powell physically harming the boys prior to their death? No. And throughout your investigation and time, when you were working with West Valley PD, did they ever relate to you that Josh Powell sexually or physically harmed the boys? No. The lead investigator, Detective Maxwell, July 21st, he testified to this question. And do you recall being asked at that time whether or not you had communicated any concerns about the boys to Washington State? His answer, if I remember correctly, I did not express any concern as far as their welfare because I didn't have anything. I didn't have any evidence that they were being abused. So another question I asked him, same date, July 21st, Mr. Maxwell, do you recall that you had no concerns regarding sexual abuse or child abuse directed to Charles and Braden while in Utah? Answer, I was not aware of any child abuse or sex abuse. This is the lead investigator of Susan Cox-Powell's disappearance, his testimony, and when the boys were put into protective custody, more than 21 months had passed, and he had been involved in that investigation. On the 22nd of July, I asked, did you state any concern that Josh Powell would harm or possibly harm the children of Washington Social Services? His answer was no. And I'm going to skip over. We've got testimony from ARNP, Michelle Breland. We have the testimony that you just heard last week from Dr. Whitehill. Testimony from Paula Strickland about what she knew. Well, if you recall, I asked, during your interactions with the Powell boys, Charles and Braden, did you learn at any time from either one of the boys of any alleged physical abuse or harm that had been perpetrated by their father, Joshua Powell, on them while in Washington State? No, I did not. That was on July 23rd. I also asked her, but during your interaction with the boys over a course of about 3.5 months, did either one of the boys indicate that they feared being around their father? She said, no. That was part of the problem with the adjustment initially, is because Charlie, of course, who was the very, very verbal one, wanted to be with his dad. He was very clear, I want to be with my dad. And I think that's part of why he resisted the grandparents because, well, he said it. It's not what I think. He said because he thought if he liked it there, he would have to stay longer. And his goal was to get out with his dad. We asked Mr. Downing when he testified on March 2nd. Now, at the time of the non-parental custody action, did you advise the court of any known physical harm or violence to Braden and Charlie that had been perpetrated by their father, Joshua? His answer was, not that I can remember at this point. Well, do you know if there had been any known facts of any harm or violence to? He cut me off and said, I do not. Mr. Serrano on March 16th was asked, if allegations were the same for Josh Powell through the whole case, then why did visitation get increased or moved? Again, he's the advocate, special advocate for these boys. So the reason why the children came into care was because there was an investigation in regards to Sdn Powell's home. The children came into care based on that. There was really no allegation that he abused or neglected his children. There was more of the stuff that was happening in that home. So we demonstrated throughout this short review period from the time that he agreed to the order of dependency to the first review hearing, he demonstrated that he could properly care for his children. Now, I'm not going to read the rest of that because that's the same observation that Dr. Manley had. And read his report regarding visitations. Here, Jennifer Graves, February the 25th. What was the purpose for the declaration that you signed and filed with the court in 2011? To help reinforce the fact that Charlie and Braden were better off with Chuck and Judy, that they would be safer in their custody than with my brother and my father. Are you able to, within the 3.5 pages of this declaration, explain to the jurors where in this declaration you advised the court that you believed that your brother was going to harm Braden or Charlie? I don't know that I put it in this. What was the purpose of the declaration then? Did you mention to the court any domestic violence between your brother, Josh, and your sister-in-law, Susan? I did not specifically say that in this document, but she claims later that she told Rocky, which I believe was the very next day, if she told Rocky that, it would be in his case note. Read that case note. So during the dependency and resolutions, as we went through the dependency, we just indicated that many of the allegations, they were either resolved or Mr. Powell had removed himself because, again, there was concern about safety in the Sdn Powell residence. The boys never returned to that residence. The date they were removed and put in protective custody, they never went back to Sdn Powell's residence. Now, we submit to you that undisputed facts before Judge Nelson include an allegation in the Powell's parents' 1992 divorce action were evaluated and reported in Dr. Manley's reports to the court. That Mr. Downing informed Judge Nelson that the Cox family feared that Josh could turn on his wife, he could turn on his boys. Now, we heard some testimony about that from Assistant Attorney General Long just last week. That's something Judge Nelson was aware of. That statement was made directly to her by Mr. Downing. This is all information she had when she entered her orders in her last order on February the 1st. Judge Nelson had the power to regulate all visitation in that dependency action. During the October hearing, Judge Nelson was advised by Jeffrey Bassett about Josh's relocation to his own residence. Then Jeff Bassett filed a motion for the in-home dependency with information that you're going to read in that exhibit. The ISS piece filed by Ms. Jacobson has detailed information, and I would encourage you to again review that. So we heard and we saw these slides that Ms. Raymond was provided in her direct examination as the first witnesses for the plaintiff. The first witness for the plaintiffs. Ms. Raymond, who last worked for the state of Washington in 1985, she testified that she had been initially around 1985 engaged by the state on approximately 30 cases as a consultant, potential expert witness. But after that date, she's handled approximately 170 more cases she testified to, all for the plaintiffs. All for the plaintiffs. I would submit to you that Ms. Raymond's testimony is subject, is biased, and you should evaluate it that way. But here, these red herrings, that the CPS, they closed their investigation too early and therefore closed the case on protecting the boys. The only thing that was closed, according to their policies and procedures, was the administrative part of the CPS investigation with an unfounded finding. It didn't stop anything at all regarding the dependency, the services that were being provided, and were ongoing at the untimely death of these boys. That DSA should have conducted a DV assessment throughout the life of the case. Well, we heard earlier at the testimony from the workers, this was not a domestic violence case. And as much as the plaintiffs want to make it so, it's not. DSHS should have contacted collateral sources in Utah regarding Joshua Powell and Susan's relationship. Well, one, we contacted the lead investigator for the investigation into her disappearance. And you heard that we don't interfere with police investigations, and there was 2 of them that were actively ongoing. Josh Powell had not been ruled out of the charges and the information, the child porn that was found in his father's residence. She also said that one of the red flags, red herrings, that Joshua had delusional thinking. Well, we went over that with Dr. Manley concerning where the word delusional was and what context. Things need to be put into a proper context. Now, in concluding here, several things I wanted to bring up. And if you're several of the other exhibits that I think you would have interest in is Exhibit 307, an email from Rocky Stevenson, which corrected Detective Sanders when he said that we weren't aware that he got a new residence. Well, in fact, on November the 4th of 2011, Mr. Stevenson sent Mr. Powell's new address to him so he'd be aware of Mr. Powell's new residence. Also, Exhibit 331. That's an email between Elizabeth Griffin Hall and Forrest Jacobson. And Forrest is advising Miss Elizabeth Hall that they're considering moving the visits to Mr. Powell's home. And Miss Jacobson inquires and asks if she's comfortable with that move. Her response is Exhibit 331, and you'll see the communication there. Communication also included guardian ad litem Serrano, who you'll see in the orders that were issued by the judge, visitation decisions had to be in conjunction with not just Forrest Jacobson, but with the guardian ad litem. We aren't making unilateral decisions here. People are being considered and consulted. There was multiple eyes in this case. Now, we heard from Dr. Clifford Nelson here sometime about 2 weeks ago. And we've had 3 different doctors testify about the injuries that were sustained in this matter by Charles and Braden. And I submit to you that Dr. Nelson was the one with the most relevant information, where he said that as soon as the boys were struck by their father, that the injuries that were sustained subject them to be unconscious. And as they were unconscious, they had no pain and did not suffer. He explained to you how the ethanol from the gasoline could be absorbed into their systems, but you've heard the testimony about the devastating injuries that were caused from being struck by Mr. Powell, what he did to his sons. I'm going to submit to you that Mr. Powell is the sole cause of the murder of his sons. It was not due to any negligence by the state of Washington. It was Mr. Powell who did this. There was no history of prior abuse, no history of any prior harm that he had ever subjected his sons to. And it was reasonable and not foreseeable for entities, acts, or admissions, and not by what the facts and circumstances may appear to have been after the time of occurrence. Throughout the course of this trial, we've heard so many new facts, so much new evidence that was never known to the state of Washington. We had all kinds of details. In fact, if you recall, I asked this psychiatric expert, Dr. Adler, he was talking about seeing forensic interviews with Charlie the day after his mother disappeared in Utah. And I asked him, where did you get that information? Because you've heard testimony from former Detective Maxwell that it was subject to a secrecy order in the state of Utah and a gag order within their department. I asked Dr. Adler, well, aren't you, in hindsight, evaluating this case? And if you recall how he would spin things, he sat there and told us, well, I don't think it's hindsight. I asked him to define it for you. Since a long time ago, I'm sure you might not recall that, but this instruction is about hindsight. And we believe that it has an effect on people's perceptions. The special verdict form that you've been provided, the very first question was the state of Washington negligent? We're going to ask you to answer that no. Once that's done, whoever you select as your foreman should sign this and return it for the court's consideration then. I'd like to